I know we're getting started later than usual, but I want to say I appreciate everybody being here. And for all of you who were at the Craig County Open Carry Day today, it was a good time. I think had a good turnout with the crowd. I think everybody enjoyed themselves. And hopefully we'll have further annual Open Carry Days. I'm not going to hold this up too long, but I want to say that we have with us a guest tonight, Mr. John Ainsworth. For you all that haven't met him, we've been trying to work it out for a couple of years on and off to have him come up and be our guest. I think we're in for a real treat. Maybe we can learn a little bit. And he's, you know, as always, guests have travel expenses and so on. And I know we haven't been here for a couple of months, but now that the election is over and locally our side, I think, made a pretty good showing. I think Roanoke County and Craig County is in pretty good shape at the moment. Thanks to Jesse and Al. Appreciate you guys. And if you don't already know John, I'm basically going to let him tell you about himself because he can do a lot better job than I can. But as we get started, I'm going to pass our donation can around, and you know we always got to pay the bills. So if you can help us out, we appreciate it. If you can't, that's okay. If you're ready to go, John, I'm going to let you introduce yourself.
I'm born and raised in Charlotte, North Carolina. I come to a realization that America was going down the tubes around 1990, believe it or not. And a lot of people had come to the conclusion a lot earlier than that. I wasn't really going to talk a whole lot about how I came to this conclusion of what I'm about to present you, but who I am is I'm a constitutionalist. Okay, I'm not a Republican, I'm not a Democrat, I'm not Tea Party, none of that. I'm a constitutionalist. What I'm about is getting America back to its original intent, constitutional foundation. We as a people are a confused people. We don't know how we got here. We think it kind of rattled out. We think it might be the progressives, it might be the Bilderbergers, it might be the Federal Reserve, it might be different presidents. You know, it could be judicial activists in the Supreme Court. We just don't know. I'm going to give you a presentation tonight that's going to show exactly what the problem is. And once you know exactly what the problem is, you'll know what the solution is. We're losing our country.
Yeah. Yep.
And I'm up here talking in Virginia. And I'm hoping to find Virginians that won't act like what I thought Virginians were. When I think of Virginians, I'm thinking Patrick Henry.
Yeah.
I'm thinking of people who want the animated contest for freedom rather than lying supinely on our backs while we're just getting run over. We're looking for people who want to stand up for what is true, what is moral, what is just, and what is lawful. So, if you're a constitutionalist, this is for you. There's a lot of different views out there, I know. There's a lot of people coming in here from a lot of different directions. But we are constitutionalists, and we're looking for constitutionalists. Now, I'm going to tell you a little bit about where I came from. In 1990, I got involved in the movement, the Patriot movement, and I found a lot of confusion there, and I started a study group. And my study group, all we did was read documents of what the Patriot movement was putting out. And in doing that, it led me to this. This is one of the first documents I came across that led me on my path. This is Senate Report 93-549. It's Emergency Power Statutes, Provisions of Federal Law. Let me see. Provisions of federal law, now in effect, delegating to the executive, which is the president, extraordinary authority in times of national emergency. Now, this came out in November of 1973. Okay, Nixon was the president. Charles Matthias, Frank Church were the chairs on this. This wasn't some junior committee. This was the heavy hitters. Read this first sentence right here. Actually, I think it's right here. Yeah. It says, a majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. And the last sentence of the first paragraph says this, and in the United States, actions taken by the government in times of great crisis have, from at least the Civil War, in important ways shaped the present phenomenon of a permanent state of national emergency. How many people here, when you were going, 1973, I was in high school. I graduated high school in 1975. Okay? Government operates in one of two modes, peacetime or emergency. In emergency, rights and constitutional guarantees are suspended. You know, if you've got the Nazis here and spies, you've got to relax that stuff. How many people knew in 1973 that we'd lived all our lives under emergency rule? Very few. I didn't. Now, if we're living under emergency rule, and they're not teaching you under emergency rule, how do you get out from underneath it? You're denied remedy. Here's page 184 from the same document. It says, the President, with the approval of Congress, has thus used as authority for extraordinary actions laws which have no real relationship whatsoever to existing circumstances. As a consequence, a national emergency is now a practical necessity in order to carry on what has become the regular and normal method of governmental action. While were intended by Congress as delegations of power to be used only in the most extreme situations and for the most limited durations, have become everyday powers, and a state of emergency has become a permanent condition. That's the suspension of constitutional guarantees, is a permanent condition. Do they teach that in our schools?
No.
Can you fix it if you don't know it?
No.
Does the United States Congress know it?
Probably not.
This is a Senate report from the United States Congress.
But do they know it? Do they read it?
I can tell you a whole lot of history on this. I don't have time. They know it. But what I want you to look at is what I have highlighted in blue. Action taken by the government from at least the Civil War.
Yeah.
Because in 1990, when I got involved in this movement, everybody was going back to the Federal Reserve Act. Everybody's going back to the bankruptcy, all sorts of different things. Nobody was going back to the Civil War. Here's another document. This is the Williamsburg Resolve. This is the Republican Governors Conference of 1994. And it says this. Here and other colonial capitals, the nation's founders first debated the idea of independence and the fundamental principles of freedom. Then the challenge to the liberties of the people came from an arrogant, overbearing monarchy across the sea. Today, that challenge comes from our own federal government, a government that has defied and that now ignores virtually every constitutional limit fashioned by the framers to confine its reach and thus guard the freedoms of the people.
True.
Now, I was always told that you can substantiate a fact on two witnesses. We got the Republican governors of the United States Senate saying the federal government is not operating by the Constitution, have no intention of operating by the Constitution. James Madison says this, knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. Who here thinks the people should be the governors? The people the sovereignty should reside in the people, rather than Congress down. The people, but knowledge will forever govern ignorance. Do we have the knowledge it takes to be self-governing? Do we have the knowledge it takes? Do we understand how we lost it? Because if we don't know how we lost it, we don't know how to get it back. Well, let's do a little quick lesson here. What's a state? Anybody ever look up the actual definition of a state? Because when I hear people talk about the state, it's always with the intention that the state is the government. Well, the state's not going to allow you to do that. The state's not going to allow you, right? Okay. What's the definition of a state? This is Westlaw's definition of a state. State, government, in its most enlarged sense, it signifies a self-sufficient body of persons united together in one community for the defense of their rights and to do right and justice to foreigners. In this sense, the state means the whole people united into one body politic. The state and the people of the state are equivalent expressions. So what's the state? The state is the people, not the government. The state's the people. The people come together to get a constitution that governs them. That's the Constitution for the state. Not the Constitution for the government. It's the Constitution for the state. The state is the people. It's the Constitution for the people. So who the body politic is defines And what constitution you have operating defines whose state it is. The state is the people. Now, to what state, to what body politic was the title and soil of, you put Virginia in here, transferred to? Who was authorized to exercise lawful jurisdiction over the soil of Virginia? The Treaty of Paris of September 30, 1783 is a legal document transferring title. And Article 1 says, His Britannic Majesty acknowledges said United States, New Hampshire, lists them all, Virginia, North Carolina, South Carolina, to be free, sovereign, and independent states. Does it say that they are a free, sovereign, and independent nation of one?
No.
We've got 13 different states that he treats them as such for himself, his heirs, and successors, and relinquishes all claims to the government, propriety, and territorial rights of the same, and every part thereof. This is a title of transfer from the crown to the free men of Virginia that fought that war. Was this a transfer of title to everyone living in Virginia? No. Were there Tories living in Virginia? People had allegiance to the crown?
Yeah.
1776, how many states, how many different body politics were operating in Virginia? 2. One says we're loyal to the crown. That's our body politic. That's who we have our allegiance to. One say they're a bunch of criminals. We of right ought to be a free and independent state. We're going to organize as a state. We're going to get our constitution, our body politic. So just because the people live on the soil doesn't mean they have adhered themselves to your body politic. They're not part of it. Were the American Indians part of the body politic? Was this a transfer of title to the American Indians? Was it a transfer of title to the Frenchmen passing through or living in Virginia? No, it was to a specific group of people, the Virginians, that fought and won. It was their blood that was spilled fighting for independence. This is some North Carolina stuff here. But what I'm going to do is show you what happened. And this happened in Virginia also. Now, I've got my North Carolina slides up here. I'm from North Carolina. Most of my talks are in North Carolina. But this is the original North Carolina Constitution. You can look at your own Virginia Constitution. Who is this for? Who are the people of North Carolina? Well, the preamble says for the freemen of North Carolina. Who can vote? The freemen, age 21, blah, 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 freemen. That's the body politic. Freemen of North Carolina. Suffrage eligibility in 1868. This is the new Constitution put in place by Reconstruction. What changed? This is what the federal government changed the state of Virginia to. You're going to say pretty much the exact same thing. Who can vote in Virginia in the 1868 Constitution? I'm going to go through all this stuff. Every person born in the United States and every person has been naturalized 21 years of age. Is every person born in the United States residing in Virginia the same as the freemen of Virginia? Okay, it's changed. 2 different states. I'll give you an analogy here. The European Union. The European Union actually is kind of like the United States was at the very beginning. It was a union of sovereign states. The European Union had certain enumerated limited powers. They did a common money. Didn't we do a common money? They treaty as a body rather than independent. Isn't that some of the powers we gave the federal government? They wage war as a body. They're united as a body. That's what we did. But is there a difference between only the citizens of France being allowed to vote in France and every person born in the European Union can vote in France? Is that a different body politic?
Yeah.
Okay? That's what they did to us. They changed it. Okay? Again, which body politic did the king transfer the title of the territory of Virginia to? Again, pretend that's Virginia. The Virginia Constitution, the Virginians, or anyone born in the United States residing in Virginia. Who legally has a lawful title, to exercise lawful title over the soil of Virginia. It's only been transferred to by the Treaty of Paris to the Virginians. Which body politic is a free, sovereign, and independent state? Every person born in the United States residing in Virginia, is that a free, sovereign, independent state? when it's composed of the exact same citizens that are in North Carolina, the exact same citizens in New York, the exact same citizens in California. I got on the internet today, looked up the Virginia voter registration application. You can only vote in Virginia if you're a United States citizen residing here. A citizen of Virginia is not allowed to vote in Virginia unless you say, this state, you're a citizen of this state. You know, if you say you're a state citizen, you're really a citizen of the state that's composed of United States citizens. But you're not allowed to vote in Virginia as a state citizen. Read that application. You sign it under penalty of perjury. That's a truthful statement. You're accepting the United States citizenship status. You're accepting stepping away from your Virginia state status. How did this change happen, and what does it mean? Was the Constitution of the United States designed to be a national government or a federal government? Today, these two terms are kind of synonymous. National government, federal government is kind of both the same. Big, huge deal in the 1770s, or 1780s. When we went from the Articles of Confederation to the Constitution, are we creating a national government, or are we creating a federal government? Are we creating a federal union of states, or a nation of one people? Which one are we doing?
Federal union.
We're making a federal union, okay? Well, how many people are familiar with the Federalist Papers? Okay? And for those who aren't, the Federalist Papers were the New York editorials written by John J. Hamilton and Madison, explaining what this Constitution was that's being proposed. What is it? You know, what's the definitions? What does this mean? What are we creating, national or federal? Now, what did the Constitution create? A mixed. It was a federal union with certain enumerated national powers. They could wage war as a body, they could treaty for all the other states, they could print the money. Article 1, Section 8 gives a list. They had certain national powers. Okay? But everything else retained. The states got to the 9th Amendment, 10th Amendment. Everything else was reserved to the states. Well, James Madison said that. He's talked about that. He brought this idea, you know, this concept. You know, are we creating a national government or a federal government? And this is what I read today in Newcastle. It says the idea of a national government involves in it not only an authority over the individual citizens, but an indefinite supremacy over all persons and things, so far as they are objects of lawful government. Among the people consolidated into one nation, this supremacy is completely vested in the national legislature. In this relation, then, the proposed government cannot be deemed a national one, since its jurisdiction extends to certain enumerated objects only. Okay? So they're saying, Madison is saying, we're creating a federal government as far as the people, the individual citizens are concerned. A federal government. Now, in the Constitution, is Congress granted authority, exclusive authority, exclusive jurisdiction over any area? The answer is yes. They can pass exclusive legislation in all cases whatsoever not to exceed 10 miles square. North Carolina doesn't have a right to say what they do in that 10 mile square. Pennsylvania doesn't have a right to say what they do in that 10 mile square. Okay? They can pass exclusive legislation in all cases whatsoever. Is that a limited legislation? No, exclusive. Whatever they want. Exclusive legislation. And what are the people, what is the citizenship of people who reside in the District of Columbia? What is their citizenship? They're United States citizens. Congress can pass exclusive legislation over United States citizens in all cases whatsoever. Madison says this, if we are a nation of one people, if we have a national government, it's not only an authority over the individual citizens, but an indefinite supremacy over all persons. But he says this is not what we're creating, the federal Constitution. What's the most propagandized period in American history?
Civil War.
Yeah, thank you. Okay, the victor writes his story, and we all know what that means. They get to tell it the way it is. Now, let's look at the other side of this man's story. This is Abraham Lincoln's first inaugural address. And I'm just going to beat down, I don't know how much of this, I may skip through some of this because I think a lot of you guys may know a lot of it. But Abraham Lincoln, well again, this is an inaugural address. I'm going to deal with the issue of slavery just real briefly here. This is Abraham Lincoln's actual handwriting. This is his, first, this is his speech that he wrote. It's in the National Archives. Let's just read it. And I superimpose the words right over the top of his handwriting. So the sentence is right below it. He says, I understand the proposed amendment to the Constitution has passed Congress to the effect that the federal government shall never interfere with the domestic institutions of the states, including that of persons held to service. To avoid misconstruction of what I have said, I depart from my purpose not to speak of particular amendments so far as to say that, holding such a provision to now be implied constitutional law, I have no objection to its being made express and irrevocable. There was a proposed amendment. It was proposed, I think, 4 days before he was inaugurated, that was going to make slavery permanent and irrevocable. In his speech, he says, I have no problem with that. How many times have you ever read that in reading about Lincoln? There it is in his handwriting. Now let's look at Mr. Lincoln's belief that all government right comes from the consent of the people. July 4th, 1861, Lincoln called together a special session of Congress to wage war on these southern states that had seceded. And I'm going to go through, we're going to get his justification for that. And again, like I said today, think about it rationally, people. This nation was founded on the principle that all government of right comes from the consent of the people. The people have a right to alter or abolish it whenever best secures their rights. When South Carolina chose to secede, what did Abraham Lincoln say? All government of right does not come from the consent of the people. All government of right comes from the consent of me. And you don't have my consent. What you're doing is illegal. It's a crime. He was acting like George III. Okay, this is Lincoln in his special session to Congress. He says this: they, the southern states, invented an ingenious sophism. Sophistry is a subtly deceptive reasoning or argumentation. Sophism is an argument apparently correct in form, but actually invalid, especially such an argument used to deceive. So he's saying the South invented this deceptive argument. The sophism itself is that any state of the Union may, consistently with the national Constitution, and therefore lawfully and peacefully, withdraw from the Union, without the consent of the Union or any other state. Okay? Let's just look at this. Is secession part of our history? Now, what is secession? Formal withdrawal from an organization. What's the Declaration of Independence?
Secession.
It's a secession document. We are formally withdrawing from you. He says, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station of which the laws of nature and nature gods entitled them. Is that secession? Is that formal withdrawal? We're giving you notice we're leaving?
Yeah.
Okay, Abraham Lincoln says, they got this wild notion. Secession is what we've done or will do. Let's go again. It says that whenever any form of government becomes destructive of these ends, it is the right of the people, a right. Does it say it's a suggestion that the people can do it if they kind of want to, if the government doesn't get too forceful? No, the right of the people to alter or to abolish it. The Declaration of Independence says it's our right to be an American, to be in one of these states, that we have a right to alter our form of government, which most likely say to affect our safety and happiness. We've got a right. But then it goes on and says it shouldn't be done for light and transient causes, but it also says that people are likely to suffer, while evils are sufferable, than to right them. Is that where we're at today? Mm-hmm. We're suffering rather than righting it. Mm-hmm. I want to find people who want to right it rather than suffer it. Now, Abraham Lincoln didn't even agree with Abraham Lincoln. But again, this is Abraham Lincoln's handwriting. This is his speech. that he gave in the House of Representatives January 12, 1848 concerning the Mexican War. And here's his handwriting actually saying the words, and here's what it says. Any people anywhere, being inclined and having the power, have the right to rise up and shake off the existing government and form a new one that suits them better. This is a most valuable, a most sacred right, a right which we hope and believe is to liberate the world. So in 1848, he says it's a right to any people anywhere. It's an invaluable right. 13 years later, it's where do these people get off? They just created this ingenious lie, this sophism, that they can do this. The seceders insist that our Constitution admits of secession. Well, let's look at what Article 7 of the Constitution says. Again, secession is formal withdrawal from an organization. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. What was going on right here? We were organized under the Articles of Confederation. Wasn't working well, they proposed the Constitution. Well, how are we going to switch from the United States of America, under the Articles of Confederation, how are we going to switch to being under the Constitution? Article 7 says, okay, the ratification of conventions of 9 states, how many states were in the Union then?
13.
13, shall be sufficient for the establishment of the Constitution between who? The states so ratified. Was it once 9 states ratified it, it became binding on all 13? No. 9 states had to withdraw from the article, say we want that form of government. Once 9 states had successfully withdrawn, seceded, the Constitution of the United States went into effect. Let's look at that timeline. This is the ratification of the United States Constitution. You got your 9, all the way down to New Hampshire. The Constitution goes into effect June 21st, 1788. But because of traveling distances by horses and carriages, they couldn't get everybody together all at one time. It took a while for them to inaugurate the new government. But by the time they inaugurated it, Virginia and New York had been added. Okay? On February 4th, 1789, George Washington is elected president. March 4th, 1789, the United States government meets for the first time and George Washington is inaugurated. North Carolina entered the Union November 21st, 1789. How many states were in the American Union, were in the United States of America when it was inaugurated under the Constitution? 11. They had all seceded away from the Articles. So they left North Carolina and Rhode Island out there by themselves. North Carolina says, we're not coming in until we see some action on the Bill of Rights because we don't trust that government. Okay? We were an independent, sovereign nation for 8 months. Rhode Island was out for 14 months before we had all 13 states in the United States again. So from July 4th, 1776, we were not a nation of all states staying in the nation to the present day. When we went to the Articles of Confederation, from the Articles to the Constitution, 2 states were not in the Union, did not come in until later. What did the southern states do? And I apologize, I don't have Virginia on this one. I just kind of did some for when I do a presentation. But what did they do? Now, what does Article 7 of the Constitution say? The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Well, when the southern states decided to secede, what did they do? South Carolina held a convention. They voted to secede. Florida held a convention. Alabama held a convention. Georgia held it. They used the exact same method in the Constitution. And what did Mr. Lincoln say? Let's go back and read his words. The seceders insist that our Constitution admits of secession. It does. It does. He says this, the express pledge by each and all, the original 13, in the Article of Confederation, that the Union shall be perpetual, is most conclusive. He's absolutely right. He is absolutely right. The wording in the Articles of Confederation that the Union shall be perpetual is conclusive. It's written in there. Were the Articles of Confederation perpetual?
No.
Well, they weren't. Was the word perpetual put in the Constitution? Seems like we left that word behind because it wasn't working too well. Now let's just look at it. The term perpetual occurs and in fact, the title of the Articles of Confederation is the Articles of Confederation and Perpetual Union. I mean, you can't get away from it. The term perpetual occurs 5 times in the Articles of Confederation, and it's in the title of the document. Article 13 says, and the Articles of this Confederation shall be inviolably observed by every state in the Union and shall be perpetual. Were they perpetual?
No.
Every state in the Union recognized the fact that the states had a right to alter their form of government, and that was a higher right than the words in this document right here. The term perpetual was dropped from the Constitution of the United States and appears 0 times. The federal government and union created under the Articles of Confederation, in fact, was not perpetual and was seceded from. Much is said about the sovereignty of the states. In fact, I heard one of the speakers after me talking about the sovereignty of Virginia. Okay, what did Mr. Lincoln say? He says, but the word is not in the national constitution, nor, as is believed, in any of the state constitutions. This word sovereignty, because he's going against state sovereignty. Well, Treaty of Paris, let's go back to what the Crown say we were. Free, sovereign, independent states. Okay, he's right, it's not in the Constitution, but let's see if we get it written down anywhere. Article of Confederation, which he quoted before, says each state retains its sovereignty. Okay, that was in the Articles, he's not quoting that part. Federalist Papers 39, in drafting the Constitution, ratifying the Constitution, each state in ratifying this Constitution is considered as a sovereign body, independent of all others, and only to be bound by its own voluntary act. In this relation, then, the new Constitution will, if established, be a federal and not a national Constitution. If it's a national Constitution, once in, you can't get out. We're going into sovereign bodies, a federal union. He says it's not in any of the state constitutions. Massachusetts Constitution 1780. The oath of allegiance you have to take is, I do truly, sincerely acknowledge, profess, testify, and declare that the Commonwealth of Massachusetts is and of right ought to be a free, sovereign, independent state. The people of this Commonwealth have the sole and exclusive right of governing themselves as a free, sovereign, independent state. They say it again. Say it 3 times in the Massachusetts Constitution. How many constitutions did Lincoln see it in? None. Was he a lawyer? Did he have the authority of the Attorney General and every power to go search 30 constitutions, see if the word's in there? He's pitching it to the people, it's not in there. Vermont, representatives so chosen, they shall have all the powers necessary for the legislature of a free and sovereign state. Tennessee, Article 32, contained within the charter limits of the state over which the people have the right of exercising sovereignty and right of soil. Is sovereignty part of what this nation was about with the states? Mm-hmm. Absolutely it was. What did Lincoln say? Much is made about this word sovereignty. It really doesn't exist anywhere. You guys are just making it up. Because he's a nationalist. Abraham Lincoln was a nationalist, not a federalist. He wanted to nationalize. So to him, leaving the Union was a crime. How strangely will the tools of a tyrant pervert the plain meaning of words. I can read the word sovereignty. I can read those words. He says they weren't there, they didn't exist. I'm not going to do this part. I'm going to show this letter to you right here. When Abraham Lincoln called on Governor John Ellis of North Carolina, North Carolina had actually voted to stay in the Union a week before Lincoln was inaugurated. We voted not to secede a week before Lincoln was inaugurated. And so when South Carolina and Virginia was still in the Union, and so was Arkansas and Tennessee. But when Fort Sumter was fired on, Abraham Lincoln, through the War Department, sent a letter to Governor John Ellis of North Carolina, and he wanted 2 regiments of troops to put down the rebellion in the seceded states. John Ellis wrote this back. This is the entirety of his correspondence. Your dispatch is received, and if genuine, which its extraordinary character leads me to doubt, I have to say in reply that I regard the levy of troops made by the administration for the purpose of subjugating the states of the South as in violation of the Constitution and as a gross usurpation of power, I can be no party to this wicked violation of the laws of the country and to this war upon the liberties of a free people, you can get no troops from North Carolina. Doesn't that nail that on the head? Where does Lincoln get the constitutional power to wage war on states to leave? Article which? Section which? Where is it?
Not there.
Same place Obama finds it.
Yeah, there you go.
Obama likes to correlate himself with Lincoln, and I do too. Lincoln destroyed this country, Obama's destroying it at the next stage. In my humble belief. How many people here have read The Object of the American Civil War that passed Congress? There's 3 back there at my table. Well, once you read what the official object of the war that passed Congress was, you'll know why they don't teach it. The object of the war passed the United States Senate July 25th, 1861. Oh, by the way, I'm going to share this to you. This is out of the Congressional Globe. It's now the Congressional Record. It was presented by Andrew Johnson, Senator from Tennessee, later President Johnson. And it's actually under the title, the heading, Object of the War. And here it is, resolved of the present deplorable Civil War, and it's at the bottom of one page, and it goes to the top of the next page, right up here. So I wrote it in a font that we can actually read. Resolved that the present deplorable Civil War has been forced upon the country by disunions of the southern states, now in revolt against the constitutional government and in arms around the capital. That in this national emergency, Congress, banishing all feeling of passion or mere resentment, will recollect only its duty to the whole country. That this war is not prosecuted upon our part in any spirit of oppression, nor for any purpose of conquest or subjugation, nor for the purpose of overthrowing or interfering with the rights or established institutions of the states, but to defend and maintain the supremacy of the Constitution and all laws made pursuant thereof, and to preserve the Union with all the dignity, equality, and rights of the several states unimpaired. What's the established institutions he's talking about here? Slavery. It's not for the purpose of overthrowing and interfering with the rights or established institutions, or the institution of slavery. Why? 30% of the slave states fought for the North. How many people are taught that? Delaware, Maryland, Kentucky, Missouri, and then West Virginia came in as a slave state halfway in 1863. But they actually worked out a stipulation they had to get rid of slavery. You had 4 slave states fought for the Union. The entirety of the war. Do they teach that? They don't teach a whole lot. And the one thing I want to say, this is just a breakdown of that. The war is not for oppression, conquest, subjugation, remember those 2. But it was to preserve the Union with all the dignity, equality, and rights in the several states unimpaired. Just remember that. The war was over. Now what this is about is Lincoln really thought of the war as a police action. The Confederate States was not a foreign nation, was not independent. They were merely states in rebellion to lawful authority. They had not left the Union. They had no right to leave the Union. Okay, they were always in the Union. So let's do the timeline. The war is basically over in 1865. In December of 1865, the 11 previous Confederate states are considered back in the Union, to the degree that they participate in amending the national constitution abolishing slavery. Virginia voted to abolish slavery February 9, 1865. That's actually before the war was over. That was through presidential Reconstruction, the government put in by Lincoln, voted to abolish slavery. North Carolina did it in December 4th, 1865. Was Virginia composed of Virginians, and North Carolina composed of North Carolinians, considered back in the Union in 1865 by the federal government? The answer is yes. The federal government only sends proposed constitutions to states in the Union. They don't send them to territories. They don't send them to Canada. They don't send them to Mexico. They only send them to states in the Union. So by North Carolina, all these southern states ratifying the 13th Amendment abolishing slavery is proof positive they were considered in the Union after the war was over. Okay? Peace is declared by presidential proclamation on April 2nd, 1866. Peace is declared. The war is over. 1866. Keep this timeline going. The 14th Amendment, which I say nationalized citizenship, put into place those things Madison said it wasn't supposed to be about. Okay? The 14th Amendment is proposed by the 39th Congress, June 13th, 1866, and is rejected by all southern states except Tennessee. They ratified it. March 2nd, 1867, the first Reconstruction Act is passed by Congress in times of peace. Peace was declared in 1866. Over the President's veto, declaring that no legal governments exist in any of the former Confederate states, except Tennessee, because they ratified the 14th Amendment. They said it was based off of conquest. They had the right to annul the state of Virginia, the state body politic of Virginia, composed of Virginians. They said they had a right to abolish that through the principle of conquest 2 years after the war is over. Now, what did they say the object of the war was? Not for any purpose of conquest. They changed the object of the war 2 years after the war is over. That's the Presidential Proclamation of Peace. We won't go into that. Now we're going to go into the Reconstruction Acts. How many people have heard the term unconstitutional act? How many here knows what an unconstitutional act means? Let's look at it. This is out of a U.S. Supreme Court case, Norton versus Shelby County. Of course, all this does is just reiterate where you can find it in dozens and dozens of other places. This isn't anything new. An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Therefore, an unconstitutional act purporting to create an office gives no validity to the acts of persons acting under color of its authority. So, if we could prove that the Reconstruction Acts, which annulled the original state of Virginia and put a new state called Virginia in, composed of United States citizens, is an unconstitutional act, then the state that's in place now, this body politic and government, is not created in law. The act conferred no rights and imposes no duties. No one has a duty in law to follow it. But we've got to prove that the Reconstruction Acts were unconstitutional. This is the first Reconstruction Act, March 2nd, 1867. This is Section 5. Here's what the Reconstruction Acts did. Let me go back here. It starts out, the very first sentence is, whereas no legal state governments or adequate protection for life or property now exist in the rebel states of blah, blah, blah. Where does Congress get the authority to just declare? This is a decree. There's no legal government in your state. Why? There's no legal government in your state. Article 1, where is that? Is that constitutional? Does Congress have the authority they have? Is one of their enumerated powers, one of their delegated authorities, to declare states in the Union illegal? That don't exist? Do you think any state of the American Union would have entered the American Union if they thought for a second they had that power to annul after they entered the Union? It's an absurdity. It's an absolute absurdity. But Section 5 says this. Now what they did is they basically said the free Virginians, ones that participated in the war, you're not allowed to vote. Anyone loyal to the United States government who didn't participate in the war and from any other state that goes into Virginia, these are called the carpetbaggers, we're going to let them vote. All the freed slaves, they can vote. Anyone that participated in the war, you're not allowed to vote. And they're going to be the new body politic. And it says that when this new body, when this group of people of any said rebel state shall form a constitution of government in conformity with the Constitution of the United States in all respects, and when said state by a vote of its legislature elected under said Constitution shall have adopted the amendment to the Constitution of the United States proposed by the 39th Congress and known as Article 14, this is the 14th Amendment. So it basically says when they have adopted the 14th Amendment, not brought it up and put it up for a vote and see which way it goes. They have to adopt it. And when such article shall have become part of the Constitution of the United States, said states shall be declared entitled to representation in Congress and senators and representatives. Now, how many people here have read the Constitution of the United States? How many people know which article is the amending article? It's Article 5 of how to amend the Constitution. How many people think that Congress gives them power? Well, if you don't get it passed the way you want it, you get to annul states and say they can't come back into the Union until such time as they amend it. Are these words in this act of Congress that's in force today constitutional?
No.
This is unconstitutional on its face. They have no power to do this. President Andrew Johnson vetoed every Reconstruction Act, but the radical Republicans in Congress had a supermajority to where they could override his veto. Every one of Andrew Johnson's vetoes of the Reconstruction Acts were overridden the day he vetoed them. That day, went back to Congress, voted up, no, out, they're passed again. I highly recommend you read Andrew Johnson's vetoes of the Reconstruction Acts. They're brilliant. But I'm going to give you some excerpts. He says this: another ground on which these Reconstruction Acts are attempted to be sustained is this, that these 10 states are conquered territory, that the constitutional relation in which they stood as states toward the federal government prior to the rebellion has given place to a new relation, that their territory is a conquered country and their citizens a conquered people, and that in this new relation Congress can govern them by military power. A title of conquest stands on clear ground. It's a new title acquired by war. It applies only to territory. So what does conquest in law do? It's a transfer of title. They're saying that these 10 states are a conquered people. They own them. When you conquer, when one government conquers another people, how much authority do those people have? None. It's just accepted. But in our Constitution, is Congress authorized to wage war on states? Article 3, Section 3. Treason against the United States shall consist only in levying war against them, the states. The Reconstruction Acts are statutized treason. It's the statutized subjugation of the free people of the American Union to Congress. Don't we feel those effects today? How many people believe that the people of Virginia, of their own accord, voted to take prayer out of school? Or was it dictated to us by the federal government?
Dictated.
How many people here believe that taking the display of the Ten Commandments out of all public view was voted on by the people of Virginia, that that's what they wanted? Or was it dictated by the federal government? How many people here believe that the right to a woman to have an abortion at any time they want was chosen by the free people of Virginia? Or was it dictated to them by the U.S. government? How many people believe? This could keep going, people. Do we live in is Virginia a free sovereign state where they get to choose, or are you dictated to how you will live? This is how it happened. Andrew Johnson goes on. He says there's not a foot of the land in one of these 10 states which the United States holds by conquest. How does he know? He's the commander-in-chief of the military forces. If Congress puts out an object of the war that says this war is not for any purpose of conquest, does the president have any authority to use the United States military to go out there and conquer it? When the express written order is, there is no authority to conquer. Andrew Johnson did not conquer these states. Abraham Lincoln didn't conquer them. Abraham Lincoln put an evil, wicked war in motion. But these guys, they didn't conquer. Who conquered the state of Virginia? The 39th Congress. They said that they had the authority to annul the state of Virginia. Wait, I went backwards. Oh, wait a second. Okay, yeah, this is a transfer of title. How was the title of the soil of Virginia transferred from the freemen of Virginia to every person born in the United States? Remember, this is a title transfer. Remember, the title to the soil of Virginia was with the crown. The Treaty of Paris was a title transfer. The title transfer that gives anyone born in the United States residing in Virginia the right to exercise jurisdiction over it. Their transfer of title is the Reconstruction Acts. Were the Reconstruction Acts lawful and constitutional? Was there a legitimate and lawful transfer of title? No. But are we living under the usurpation and accepting the usurpation? All the Reconstruction Acts were passed over the President's veto. I'm going to show you this real quick. This is the Capitol building in North Carolina, in Raleigh. These are the 3 presidents that came out of, well, 2.5 presidents that came out of North Carolina. We've got James K. Polk, we got Andrew Jackson, and Andrew Johnson. Now, why I say a half a president is because Andrew Jackson was born in the Waxhaws. Okay? There's a town in North Carolina called Waxhaw, North Carolina. But the Waxhaws, the area goes all the way down to South Carolina. No one knows where he was born. So it's decided every year where Andrew Jackson is born based upon a high school football game. Whoever wins the game gets to declare Andrew Jackson their president, and so he's our half president. But Andrew Johnson, let me just show you, and under each one of these men it gives a little one-liner of what they're known for. You know, Andrew Jackson, he revitalized the American democracy. Now what does it say about Andrew Johnson? He defended the Constitution. How many people remember Andrew Johnson as the one that defended the Constitution? Bill does. I didn't know until I went up here and saw this thing. I mean, and look at what he's holding in his hand in this statue. This is the last man to defend the Constitution of the United States of America against the federal usurpation of power and centralization of all power in Washington. If you were to take a poll, the average poll, kind of taken every year, who's the worst president of the United States? Well, Andrew Johnson, since he almost got impeached, is ranked usually #1 on most of them. Why? He defended the Constitution. What was Andrew Johnson trying to preserve? What was the biggest prize that would give the federal government virtually unlimited power? Nationalization of citizens, of course. But they said the 14th Amendment and the Reconstruction Acts were designed for the freed slaves. The 14th Amendment was the second of what they called the Negro Amendments. The 13th Amendment abolishing slavery, the 14th Amendment giving blacks civil rights, the 15th Amendment giving blacks the right to vote. So, am I missing something here? Was the 14th Amendment designed to nationalize citizenship, or was it designed to give blacks civil rights? And if we attack the 14th Amendment, we're attacking blacks. I say they were designed to nationalize citizenship. But, in the way I do things, I like to prove it. This is a guy by the name of James G. Blaine. He was one of the radical Republicans in Congress. He was from Maine. He was a congressman from Maine. He wrote, he was a career politician. I'm going to quote from 2 books of his. One is the Political Discussions, 1856 to 1886, and 20 Years of Congress, 1861 to 1881. 14th Amendment was proposed in June of 1866. He gave this speech to a Republican mass meeting in Skowhegan, Maine, August 29th. So 1 month, or June, July, August, 2 months after the 14th Amendment is proposed, he goes up to tell his people what this proposed amendment is. And he says, and in making this extension of citizenship, we're talking about United States citizenship, we are not confining the breadth and scope of our efforts to the Negro. It is for the white man as well. We intend to make citizenship national. I mean, is that plain English? Okay, that was one of his speeches. This is what he wrote in his autobiography. about the 14th Amendment period, Reconstruction. Now again, this guy loves the 14th Amendment. He loves the nationalization of citizenship. He's going to be presenting it from his perspective. How many people believe we've got state rights? How many people believe it? I don't. What got rid of it? 14th Amendment. How do I know? I read James G. Blaine. He says this.
I believe we got him if we stand up for him.
I do too, as a Virginian, not a United States citizen residing in Virginia. The present state, the state that's out there now, that body politic, has no state rights. Let's read Blaine. He says, as the vicious theory of state rights have been constantly at enmity with the true spirit of nationality, the organic law of the Republic should be so amended that no standing room for the heresy of state rights would be left. This book is written in 1884. He says the first section of the Constitutional Amendment, the 14th, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, is the utter destruction of the pestilent heresy of state rights, which constantly menace the prosperity and even the existence of the Republic, and is the formal bestowment of nationality upon the wise federal system, which was the outgrowth of our successful revolution against Great Britain. He's talking about these new constitutions, this Constitution of Virginia that was put into place, Constitution of North Carolina put into place, these new governments. He says all were ordained in the spirit of liberty. All prohibited the existence of any form of slavery. Well, slavery was abolished 2 years earlier, so that was already gone. That's a little throw-in feel-good line. And all heartily recognized what? The supreme sovereignty of the national government as having been indisputably established. It's established, it's created at this point in time by the overthrow of the rebellion, which was undertaken to confirm the adverse theory of state rights. Now, remember I showed you the object of war? What was the object of war that passed Congress? To preserve the states with all dignity, equality, and rights unimpaired. Do you think New York hated their state rights so much they wanted to go to war and fight it and get rid of them? You know, we hate being independent and sovereign. We want to go under control of what? You think Ohio thought that when they were sending troops down to that war? They were going by the object of the war, which said the war was not for any purpose of conquest, subjugation, but to preserve the union with all the dignity, equality, and rights of the several states unimpaired. Did those northern soldiers fight to get rid of their own state sovereignty? No. Did the United States Congress spit on the northern soldiers' graves right after they spit on the southern soldiers' graves? Absolutely. Absolutely. The northern states did not fight to get rid of this adverse theory called state rights.
How many northern states opposed?
I don't have time to go through all that. I know about New Jersey and Ohio and withdrawal. I know all that stuff, but we're not going to do it. Now right here, the topic he's talking about is where does your citizenship come from? And remember Federalist 39 that says if your citizenship comes from the state, is what they said, because if it comes from the federal government, then you know, they have total control over you. So he says the opening section of the 14th Amendment settle all conflicts and contradictions on this question of where your citizenship comes from, the state or the national government, by a comprehensive declaration which defined national citizenship and gave to it precedence of the citizenship of a state. The 14th Amendment says this: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. These pregnant words distinctly reversed the origin and character of American citizenship. Instead of a man being a citizen of the United States because he was a citizen of one of the states, he is now made a citizen of any state in which he might choose to reside because he was antecedently a citizen of the United States. The consequences that flow from this radical change in the basis of citizenship are numerous and weighty. Okay? Is he admitting that this is an overturning of the foundation of what this nation was started as? It reversed, distinctly reversed the origin of your citizenship, the character of your citizenship. State citizens were sovereign body of people. Now, where does the sovereignty reside? In Washington, the national government.
Would you like to have a clear example of that? The voting rights law.
I don't have time. I do not have time for questions right now.
I'm not going to say.
And remember Federalist 39, the idea of a national government involves in it an authority over the individual citizens and an indefinite supremacy over all persons and things. This supremacy is completely vested in Congress. On several occasions, the Constitution now, the Reconstruction Acts were attempted to be adjudicated. Every attempt has been met with obstruction of justice. And hopefully, what I'm about to show you is going to make you mad. This first half has just been entertaining and fun. What I'm about to show you should make you mad. It should ratchet it up, I suppose. And maybe we can get some Patrick Henrys coming out here. That's what I'm looking for. First case, Georgia v. Stanton. The state of Georgia going against the Secretary of War. They're deploying soldiers down here to destroy our government. Supreme Court says this. This is came out December term. This is from the Supreme Court. Supreme Court said this. A bill to restrain the defendants, which is the United States military, who represent the executive authority of the government, from carrying into execution certain acts of Congress, inasmuch as such execution would annul and totally abolish the existing state government of Georgia, is not within the jurisdiction of this court. How many people have read the Federalist Papers? A couple of us. Okay? What did the Federalist Papers say about the Supreme Court? What was its function? To be a bulwark between the people and an over-encroaching Congress. That was one of our safeguards. How safe do you feel under this Supreme Court? Just because you have an act of Congress that's going to annul and totally abolish your government, it's not within us to really rule on that. And again, I can give you the reasons why, and I'm not going to. This is the next one. Ex parte McCardle. McCardle was a Mississippi editor. What time's it getting on? How much time do I got?
It's 8:15.
8:15?
And there won't be time for questions and answers.
Yeah, we're going to have time for question and answer. I'm going to try to zip through this. I don't think I got too many more to go, and then I'll stop. And we'll do some question and answer. Ex parte McCardle. McCardle was a Mississippi editor. You know, they're trying to reconstruct Mississippi. He said he wrote in his newspaper and basically was against it. He says that, you know, I'm totally against it. He was arrested by the United States military for impeding Reconstruction. Now again, remember the war was over in 1865. Peace was declared in 1866, and now we got soldiers on the streets in 1868. You know, forcing new states to be put in place. Well, McCardle got all the way up to the United States Supreme Court. And I don't have time to explain how he got there because Lincoln has suspended writ of habeas corpus and some other acts were passed and all that. McCardle's being defended by Jeremiah Black. Okay, so McCardle is the good guy. Jeremiah Black's the good guy. Who is Jeremiah Black? Former Attorney General to the United States. Former Chief Justice of the Pennsylvania Supreme Court. Does he know a thing or two about law? He's the one saying Reconstruction Acts are unconstitutional. Okay? Who is supposed to defend the United States against an action against it?
Attorney General.
The Attorney General. Read this. This is out of the New York Times, January 17, 1868. And this is a section on the Supreme Court, the case of Colonel W.H. McCardle, arguments of Judge Black and Senator Trumbull. It says, in the course of the debate, Mr. Attorney General Stanberry defined his position. He said that a case had been laid before the President, which a military commission had sentenced a person to death. The question had been propounded to him by the President whether the condemnation and sentence was legal. This was under the Reconstruction Acts. He had, in accordance with his convictions, answered that they were illegal and void, and had advised the President not to approve them. This being his opinion, he could not, of course, take the other side of the question. Therefore, he had declined to argue it here. he had left it to be argued by those who believed in the doctrine of Reconstruction. He had given notice to General Grant, in consequence of which other counsel had been employed. The Attorney General said, I'm not defending it. I've already given an opinion to the President they're unconstitutional. I can't take that side. Go hire your own attorney. And they hired Senator Lyman Trumbull of Illinois. How many good senators come out of Illinois? This is Jeremiah Black. We're going to go through a little bit of his argument. It says, in Supreme Court, this is March 2nd, today the McCardle case was argued on its merits. Mr. Jeremiah S. Black commenced his argument on behalf of the petitioner who has been charged with and arrested for an alleged violation of the Reconstruction Acts. He says this: a state election was going on which was superintended entirely by the Army, which by means of bayonets drove one set of voters to the polls and drove another set away from them. The whole thing was accomplished by naked terrorism. And when an unarmed and peaceable man expressed his opposition to such proceeding through his own newspaper, he was told he should not do so and was ordered into custody. He was arrested. Which of the two parties was guilty of intimidation? The accused or the accuser? It is said McCardle hindered Reconstruction. Congress desired that a certain constitution or form of government should be adopted and submitted to the people for their decision. Or it was submitted to a portion only of the people of Mississippi. The act of Congress made a show for the expression of approbation or disapprobation, approval or disapproval. McCardle was not among those who were in favor of that Constitution. This is said to be hindering Reconstruction, the commission of a crime which there was a right to punish. No judge who had a clear comprehension of his duty would ask a man to plead to a tissue of absurdities like that. Yet if the trial of McCardle had gone on before a military board, he would not have the slightest chance of escape, but would have been convicted. Military commissions never disappoint the expectations of those who order them. Okay? This is Lyman Trumbull. He's the one that defended, that the War Department hired to defend the constitutionality of Reconstruction. Did he defend that they're constitutional and lawful? No. He says, I shall commence what I have to say by denying the jurisdiction of the Circuit Court under the Act of February 5th, 1867 to hear this case, and if I establish that proposition, of course, this court cannot entertain jurisdiction of it. He's challenging jurisdiction. He's saying there was an improper procedure by which it got to the Supreme Court. He's not even trying to defend the constitutionality of it. He says, I have gone substantially over the ground which I intended to occupy. The propositions which I have endeavored to maintain are, first, that this court has no jurisdiction of the case, because the Act of February 5th, 1867 did not authorize the Circuit Court to take jurisdiction of it. Well, what happened? He was a senator. Did the Supreme Court make a ruling that day? No. Reconstruction Acts were argued for 3 days. Wasn't looking good for Mr. Trumbull. He's a sitting senator, so he had to go across town from the Supreme Court building to the Capitol building, gathered his radical Republican friends to propose a legislation that would take away the Supreme Court's jurisdiction to make a ruling on the case before it comes out. And here's how that went down. This is Trumbull. This is out of the Congressional Record, or Congressional Globe. And he's proposing this legislation that's going to take away the jurisdiction of the Supreme Court in the McCardle case, which he had just argued a couple weeks earlier. He says, in my judgment, there is no such great importance to be attached to it. It's a bill of very little importance in my judgment. And I wish to say to the senator from Maryland that the Supreme Court has not decided that any case is pending before it under the Act of February 5th, 1867. No such decision has been made, nor do I believe any such decision would ever be made. There is no such case as is pending in the Supreme Court, and there has been no case pending in the Supreme Court. Mr. Doolittle is a Democrat out of Wisconsin. He says, Mr. President, my honorable friend from Illinois seems to think there's no importance in this measure, that it affects nothing and nobody, that there is no case pending in the Supreme Court which this act will affect, that it is a mistake and a delusion on our part to suppose that there is any such case there under the law of 1867. Well, sir, if he be correct in this, why the great haste for pressing the bill? What does it mean? Sir, I apprehend that the honorable senator from Illinois is altogether mistaken in the view that he now presents. That this is a very important measure. That there is a very important case pending in the Supreme Court under the Act, which it is now proposed to repeal. The honorable senator himself, as counsel in that court, if I am correctly informed, and with other counsel, made a motion to dismiss a case pending in the Supreme Court, or alleged to be pending under the Act, and the court refused to dismiss it. We all know, the whole world knows, that this case of McCardle is pending in the Supreme Court, brought up on appeal under the Act of 1867 from the Circuit Court of Mississippi, and that case has been argued by eminent counsel, and that it's pending. It's important because this case involves the constitutionality of the Reconstruction Acts. It involves the constitutionality of those acts which have been passed by Congress. If there be no such case before the court, why does the honorable senator desire to pass a bill to take away jurisdiction of a case which does not exist? Mr. President, the truth is, and we may as well look it square in the face, it is because men know that these acts will be decided to be unconstitutional. That is the reason why they desire to take away from the court the consideration of the question. And what happened? This is out of a book on this case, a modern book, and it says, while the case was under advisement, Congress passed an act taking away the jurisdiction of the Supreme Court as defined by the Act of February 1867 in cases of habeas corpus, and the appeal was therefore dismissed for want of jurisdiction. McCardle was thereupon discharged, and no further attempt has been made to test the constitutionality of the Reconstruction Acts. And that's where we come in. Let's test the constitutionality of the Reconstruction Act. This is the only case in the history of the United States that's been argued before the Supreme Court, and then Congress came in, passed a law, and took away the jurisdiction for the Supreme Court to hear it. And were they being honest when they proposed the legislation? It was done by criminal, evil men. Reconstruction Acts have never been adjudicated. The only way to adjudicate the Reconstruction Acts, because what did the Reconstruction Acts do? They annulled the original state of Virginia. Who's the injured party in that?
People of Virginia.
People of Virginia. What about the United States citizens residing in Virginia?
No.
No. Whose government is that that's in place now? It's the government of the United States citizens residing in Virginia. Where's the government for the people of Virginia? Where are the Virginians? I need 2 pieces of paper.
We're zombies.
Shouldn't have put that in front of here. Thank you. Vanna. This represents the Constitution of Virginia, 1776, 1851, whatever. I think 1851 is your last one. This is the Constitution for the freedmen of Virginia. What is a Constitution? It's a piece of paper, right? Can this piece of paper walk, talk, do anything? What happened to this piece of paper by the Reconstruction Acts? Congress vacated it. Doesn't exist anymore, and they created a new one. They created a government, and a body politic, and a constitution for anyone born in the United States residing in Virginia. Subjugated class of people. Subjugated with benefits. Okay? Subjugated. Nationalized. Sovereignty does not reside there. Okay? Can these people say, you know what? We're the government for the free people of Virginia. Can they do that? No. This is a government where these people can't convert and all of a sudden say they are. Think of it this way. When the Nazis conquered France, did they do that legitimately? Lawfully? Did they come into France lawfully? Free people of France said, come on in, we like it, come on in. Did they set up, did they displace the government and constitution of the free French people? Did they bring in a new form of government, of people loyal to Berlin? Yes. Okay. What was the way for the free French people to exercise jurisdiction over the soil again? Weren't a bunch of people in the Nazi party? We gotta get people in the Nazi party. Oh, or maybe could the Nazi people who were loyalists, the loyal to the Nazi party, could they say, we're the free French people now. We're just gonna claim it. Do they have a right to claim it? No. You cannot convert in this system. Those representatives, those senators, they represent United States citizens residing in Virginia. They do not represent Virginians. Your Constitution is laying there on a table. It was vacated illegally. The only reason there is no free, sovereign body politic of Virginia, what's it take to make this Constitution alive? You need bodies. You need officers. You need voters. You need to start getting taxes. You need to organize. Vote people back into this thing. Recognize this as being the lawful state government, lawful government of Virginia. This one can never be converted into it. They never will. When something is stolen from you, when do you have a right to remedy? Is it by, if I get a political action committee and I go get some senators and we go, let's lobby and maybe they'll give us our state back. Is that what feel like we've been doing for so long? Begging on our knees, give us our state back, quit oppressing us. What does the law say? They're created unconstitutional. They're not even, they're a nullity in law. All it takes is, you know what, I recognize this is lawful. That's what we did in North Carolina. We grabbed the original North Carolina Constitution, which says it has never been changed by the consent of the people. We have a right to it. We have a right to be North Carolinians. The preamble to the Constitution says that Constitution was ordained for who? Ourselves and our posterity. Not ourselves and any usurper who might come around. Ourselves and our posterity. We have a right to pick it up. The issue is, do we have the backbone? Do we have the knowledge to pick it up? And what I want to do is I want to get people in Virginia to realize this is a real argument. This is all I'm presenting is a legal argument. It's a legal argument. Our legal system says if you see something that's unconstitutional, you're not bound to obey it. I mean, you can if you want. There's no legal obligation. What you are in law, if you don't agree with the unconstitutional act, you do what is lawful and constitutional. And then what will probably happen is unlawful and unconstitutional will say, you're crazy, you're committing treason, we got a problem. We're at war. The war is the subjugation of the people of the United States to the federal will against their will. Without right. We're at war. It's a true war. And whenever you're at war with someone, you've got to figure out what your strengths are and what your weaknesses are. You've got to figure out what their strengths are and what their weaknesses are. And you are here to try to figure out how to leverage your strengths, hide your weaknesses, and then leverage their weaknesses and don't go against their strengths. What are their strengths? Military, police, judicial system, a bunch of people who are like sheep, just don't even see what's going on. Media. What's their weakness?
Knowledge and truth.
The truth. The truth is their weakness. They cannot handle it. And until we bring it, we have a duty. Declaration of Independence says it is our duty to remedy this. So if we leave here and we don't do our duty, the only people we can look at when we want to claim or complain about the next Obamacare Second Amendment infringement is ourselves. Because we're acquiescing to stay under subjugation rather than correcting it. This is a legal argument. What we did in North Carolina in 1997, we reestablished the original state. I have not had a driver's license for 18 years. I don't recognize that state as lawful. They have no right to exercise jurisdiction upon that soil. I'll get a license if they can prove they're lawful. But we put in a 50-page brief, which has this in it. This is unconstitutional in space. I have not been convicted in 18 years of driving without a license. They cannot answer this. They cannot answer the truth. They can avoid it. They can call you names. And as long as we got a little small group of people in North Carolina trying to do this, they're going to run over us. Well, they're going to try to. They're working hard at it. They haven't really got close to us yet. But if we get people in Virginia going, and then South Carolina going, and then New York going. New York was reconstructed. Who can vote in New York? Can the free men of New York vote? For only United States citizens residing here. Every state was reconstructed. It's an absolute myth that only the southern states were reconstructed. Because what was the object of Reconstruction? To pass the 14th Amendment and nationalize citizenship. New York got nationalized. How many people here believe politicians are truthful? How many people here think that the best remedy is to go ask them to fix it? It's your rights. Whose duty is it to exercise your rights?
You.
Yours. Please don't abdicate that duty. So again, North Carolina, we've gotten cases all the way up to the United States Supreme Court. We are the first people to get the constitutionality of Reconstruction. What's that last sentence say? And no further attempts are made to test the constitutionality of Reconstruction. U.S. Supreme Court, Isaac Hutchinson Birch, he's one of our citizens, recognizes the original Constitution of North Carolina as being lawful and binding and does not recognize that usurpation of power. Had this filed with the United States Supreme Court, January of 2012. They did not hear it. But here is, and you got a copy of that brief back there? We actually have a copy of this brief here. This is the very first page of it. Thank you, man. This is a brief to the United States Supreme Court. This is an actual one. It's just an extra copy of what we sent to them. I had one extra one made, so I'd have it. First page has to have the questions presented. What's the questions presented? Did the Congress exceed its limited and enumerated powers when, through the Reconstruction Acts, it authorized military force to nullify the constitutional government of North Carolina and to substitute in its place an electorate, that's the body politic, and a government molded to the will of Congress? And two, because what we do is when we're pulled over with any conflict, because we say they don't have a right to exercise jurisdiction over the soil. So we challenge jurisdiction. That's our whole legal argument. We challenge your jurisdiction over me, a citizen of North Carolina. We say we have right to exercise jurisdiction over this soil, not you. Treaty of Paris transferred it to us. What transferred it to you is the Reconstruction Acts. They're unconstitutional. Therefore, null and void, you have no authority. Okay, so where do you get your authority? Prove Reconstruction's law. So what we do is we always challenge jurisdiction. How was your state created? Was it created lawfully? Now, I'm going to tell you something that I have been told by prosecutors. We have no intention of answering you. What's that telling you?
You're right.
They can't win.
How many times does a state have to prove it's lawful? Once. Just once. All you gotta do is do it once. Do you think that's kind of important? What's the foundation of all law? Or the exercise of all law? A jurisdiction to exercise it in. We got these people exercising jurisdiction, and when challenged, they say, we're not going to answer you. Call your first witness. Violation of due process of law, violation of North Carolina Constitution, violation of the United States Constitution. But they can do it because we don't have enough boots on the ground and eyes on them and phone calls and emails to them to make them stop. If we can start getting people willing to stand up and confront them on this issue, and we've had nobody thrown in jail, and another thing, I'm not saying that everyone who does what we're doing has to get rid of your license and do all this. I know a lot of times that scares people and they go running away. What I want you to do is get educated of whether this is real, whether what I presented was real or not. Because you have a duty, not to say that was interesting, yeah, that's true, but this is true too. No, there's only one thing true. There's only one government that's law. The original one or the one that's in place now. And if you believe that this information means nothing, it's not going to be convicting on your soul and on your actions, and you're going to go back into that system, then you're the one that's accepting statutized treason and become a party to the overthrow. You become a party to the overthrow. As the Lord says, in talking about being hot or cold, what does he think about the lukewarm people? Spit them out. Be on, the Lord says, be on my side. Or be on Satan's side. Being on Satan's side, openly. I like you a whole lot better than those in the middle that are giving me lip service, saying they support me and want me and love you. Oh, Lord, I love you. I'll spit those out, vomit them out of my mouth. Well, same thing goes in this movement. A lot of people say, yeah, we want the Constitution back. Oh, yeah. I'm showing you. Here's how we do it, people. Are we going to give lip service, so this is the way to do it, or are we going to hop on board and get this country back? This is a movement based on knowledge and education and the law, not on, and I've been in the Patriot movement for a long time, there's a lot of crazy stuff going on out there. This is not some whack, off the charts, something I picked up on the internet. When I give these presentations, and I only gave you people 10% of what I've got, because I only had an hour or so. I can do an 8-hour seminar on this, and we can go into international law, and we can go into all sorts of directions. I want to get a group of people willing to learn more. Not to reestablish tomorrow, to learn what it takes to reestablish. Learn how we lost it so we know how to take it back. I'd like to get a coordinator up here, someone who will do that. And I want to do some questions and answers. But like I said, what we do is we challenge jurisdictions. And our second question is, when challenged with substantial evidence to the contrary, must the existing government of North Carolina prove the lawfulness of its claimed jurisdiction over the petitioner, one of the people of North Carolina? I say they have an obligation to do it. Now, one thing you know about me is I'm fairly well versed in this. I take any real question that's just not off target, going off in some tangent, dealing with the education of this, not what if this and what if that and how they're going to do this. I want to deal with this topic right here. I'll take any question. And let's just go ahead and open this up for questions. Let me get Phil first.
I've got two questions and a little comment. Number one question, if you studied international law,
Yes.
is it true that you can only do a prisoner exchange between sovereign countries, which is why Lincoln never did it, but he never allowed it but one time?
Okay.
My second question is,
I can answer. Go ahead.
you can never, ever do basically a naval blockade except against a different sovereign nation. Under international law, you can't blockade your own port. And the third little thing I want to comment is, if you look up citizenship, it's a very, very critical thing. You look in the Constitution, where citizens is capitalized all the way through till you get to the 14th Amendment, then you lowercase from there on out.
Absolutely
So
true.
you have been changed whether you realize it or not.
Right.
But I'd like to hear about the international stuff.
Okay, what he's talking about is during the American Civil War, Abraham Lincoln took the position that the Confederate States of America was not a sovereign nation. The Confederate States of America took the position that they were a sovereign nation. And so Abraham Lincoln said this is a police action. They're merely state in rebellion to lawful authority. It's just like we're going to put down the South Central LA riots. We're just going to go in there and use the military, put down this rebellion, and get peace and order put back into place. Well, what Phil's talking about came to a head was they had a Confederate naval vessel that was captured. And when this naval vessel was captured, the Yankees said, we're going to hang them all for treason. Now, what's that mean? You can only hang someone for treason if they have an oath to you and they violated it. They annulled their oath. Okay? Can you charge, when we're at war with Germany in World War II and we capture a German citizen, can we charge him with treason? No, he didn't commit treason against us. Okay? So Lincoln said, I'm going to charge them with treason and we're going to hang them all as treasonous. Jeff Davis says, we need to do some prisoner exchange. These are prisoners of war. You got to go by international law. And Lincoln said, no, we're hanging them. Jeff Davis finally said, well, whatever you do to them, we're going to do to your prisoners. And that's what got prisoner exchanges going. Okay? So that was just a little bit of a showdown of trying to maintain a legal position, but then just having to abdicate to the actual situation. They just started doing prisoner exchanges, but then the North stopped the prisoner exchanges halfway through the war because the Southern soldiers they were exchanging were going right back on the battlefield, coming back out, and they said, okay, so now we're just going to keep them. And then you got Andersonville, and then you got Elmira up in New York and Chicago and all these other dismal places that were killing soldiers by the thousands, starving to death on the North and the South. But the North had supplies, and the South didn't. Yes, sir. I mean, Phil, did I answer your question? What, did you have another part?
The blockade.
Oh, the blockade. Well, again, they considered it a police action. They had no authority. I mean, everything he did was a crime. I mean,
but by blockading the ports, he was creating them as a sovereign country. He was recognizing that because you can only do a blockade against a separate sovereign country. You can't blockade your own.
Well, you're making one fatal flaw in all your logic. You're trying to make Lincoln's position consistent. He wasn't. Now, really, I mean, really what it was he did whatever he could. He didn't obey the law in any direction. Every direction he went was illegal. And he got confronted with the legalities of it, and he just went another direction and violated something else. So as soon as you try to make logic out of what he's doing, you can't. You can't make logic out of none of this. Reconstruction, you can't make logic out of anything Congress did. It's all a crime. This is one long 8-year crime. And they violated everything. And they took this one side one day and the next side the next. It was just constant.
See that every day.
Yeah, you can't make logic and reason out of what these guys did. I got this number first.
Two questions. Before 1867, before the Reconstruction Acts and stuff like that, do you think there was any, first question, do you think there was any preconceived implementation of putting the 14th Amendment in place when they did win? Was that something that was thought of ahead of time, or is that something that happened afterwards? And the second thing, it seems to me because of the 14th Amendment, there was actually an overthrow of the government. Can you call it a revolution of sorts?
Oh, it was a revolution.
Yeah.
No, this is America's second revolution.
Right.
America's foundation is not 1776. America's birthday is not July 4th.
Right.
America's birthday is March 2nd, 1867. That's when a new nation was conceived. We should be celebrating March 2nd, 1867, go out there with our fireworks and say, we're subjugated. Hallelujah. Praise God in Washington. Okay? But what was your first question?
Was that something that was preconceived in men's minds before?
Well, again, as you can see by Lincoln's speech, he's a nationalist.
Right.
You can see it in his heart. Whether there was the 14th Amendment was already written and kind of in the wings, I don't know. I couldn't speculate on that. But you can tell they're nationalists, and that's what the desire was. And like they say, is you never let a good crisis go to waste. You know, they had it right there. Let's go ahead and put in place what we want. And they did.